Hello and welcome back. This is In Your Defense, and I'm attorney Steve Toland. Today we're going to wrap up our series on minors in Texas and alcohol. And I'm going to offer from a criminal defense lawyer's perspective only. I'm certainly not a parent expert, but in counseling families through some difficult times involving their children in alcohol over the last 20 years, I think I'm well qualified to offer some advice. So here are if you're going to talk to your children about alcohol, and I really think you should, here are 4 areas that I would cover in talking to your kids. First, go ahead and explain to them what the law is. I think a lot of times children go off to college and there are parties where alcohol is freely served and they kind of forget that, hey, that is still against the law. So if you're under 21, you're not allowed to consume alcohol and you're not allowed to possess it. That means touch it, hold it, or be immediately accessible to alcohol, like if you're in a car, and we'll explain that in a second. So first, explain the law to them. Number 2, go ahead and identify areas of risk for them. I think it's really important that kids, when they start going to high school parties or ride around in cars with kids in high school or obviously college, that they start thinking through what are the scenarios wherein I'm likely going to have these situations come up. So let them know about tailgating, what a tailgate party is, and how you can't walk with beer or alcohol in a cup on your way to a football game. Or if you're inside a house party and you step outside to maybe get some fresh air, or you're holding a drink for one of your friends outside, that can be a potential liability issue for you, riding around in a car, etc. So let them know about the areas of risk and talk those things through with them. The third tip I have for you when talking about alcohol with your minors is to go ahead and teach them about constructive possession. So if you're riding around in a car, for example, and there's a 12-pack of beer, anyone who has access to that alcohol, even if you're not actively holding it, could be charged with minor in possession through the doctrine of constructive possession. If you're at a table and there's a pitcher of beer and there's cups about, even if you're not holding one of the cups, you can be charged. So talk to them about this idea of constructive possession. They've got to be smart and think these things through. And fourth, the most important thing I really believe you need to talk to your children about when you talk about alcohol, especially those in high school, is the emergency medical exception. If ever your child is scared and thinks that they themselves or their friend has had way too much to drink and they might have alcohol poisoning, if they notify emergency personnel, that is, they're the first to call, and they stay around and wait for the help to arrive and cooperate, tell the truth about it, they are not going to be liable under the criminal charge of minor in possession or minor in consumption of alcohol, obviously even if they have alcohol on them or have consumed alcohol. So they're immune from that liability. So let your children know about that. That's extremely important. So those are my 4 areas I would include if you're talking to your children about alcohol. I want to thank you for joining in on our series of minors and alcohol, and remind you, if you have any questions about these issues we've covered or anything else about how to respond to a college application or anything like that because your child has once been given a ticket for something, reach out to me, attorney Steve Toland, or us here at Peek & Toland. We're always glad to help.